Good afternoon to those of you on the East Coast, and good morning to those of you on the West Coast. My name is Felix Shipkevich, and I am joined here with my colleague Yvonne Bowser-Caballero. Today we have an exciting webinar and have quite a lot of information packed, and we'll try to get it done in 1 hour to discuss the overview of the new CA-DFPI regulations requiring debt settlement and other registrations under the CCFPL. This presentation is quite timely, and we'll discuss why. There's a lot of information, and it's probably one of our lengthiest presentations that we put together in terms of slides. What I will do quite differently here, and what Yvonne will do a little bit differently here if you are a repeat listener or attendee of our webinar, is we're going to read slides a little bit more than we typically do, and what Yvonne will do is she'll have to go a little bit faster than she typically does in some of the slides, just because of the volume of information that we have. With that in mind, please email us directly, and we're happy to share a copy of this presentation for you, and discuss any question that you may have. Really quickly about me, I'm a regulatory attorney. I'm practicing in my 3rd decade. I'm based in New York, run a boutique firm with offices in New York, Miami, and London. I'm admitted to practice law in New York, a couple of other states where I retired my license, but also in England and Wales. I teach at Hofstra Law School. Last year, as you can see on the right, I'm very proud to publish a very lengthy and probably boring textbook on digital coins and cryptocurrencies, law and regulation. While we do a lot of work in the consumer finance law field, I do, a lot of work in other areas related to regulatory compliance, particularly those involving banks, broker-dealers, technology companies, payment service providers, crypto exchanges. So just always sort of a little introduction about myself. And now I'll turn it over to Yvonne.
Hi, everyone. If you are familiar with me, my name is Yvonne Bowser-Caballero. I've been here with the firm since early 2021, almost hitting 4 years now. I particularly focus on transactional services in the consumer finance spaces, and do a lot of work with the licensing and registration guidance. So I am here to provide you with everything you need to know as far as California's registration process goes.
Thank you, Yvonne. Yvonne is really the go-to person when it comes to NMLS, any registration licensing issues, and she knows many regulators on first-name basis, and just really excited to have Yvonne on our team for almost 4 years. I can't believe it's been that long, and exciting. A quick plug about our upcoming regulatory workshop. This is going to be our 5th annual workshop, and it's going to take place, as always, in Orange County, and specifically at the Marriott in Costa Mesa, same location we had last year. And this webinar draws debt relief industry professionals from all over the country, including not just debt relief regulatory professionals, but professionals from payment space, software space, as well as regulators. We've been very blessed to have regulators from both federal and state agencies attend and present. It's a great opportunity to one day workshop, although it starts the evening before with an opening reception, and we have a closing reception, and obviously a lot of networking and business opportunity to meet other folks in the space, which also a great reason to come out. We pride ourselves in providing content, right? And if you attended before, we're very grateful, and I hope you will come back again. We have many repeat attendees, and typically we get pretty high remarks on our content. And even if you're new to the industry, you should stop by. The tickets are not expensive. It's $75. We actually just a few hours ago announced the sale of the tickets, and all of the proceeds this year are also going to a wonderful organization which we support, Women of Debt Relief. Very proud, and we work very closely with Teresa Dotson. On this slide, we have our initial executive sponsors, and I'll tell you why we call them executive sponsors. We'll actually have probably two more join by our next webinar in the next week or two. And these organizations are very valuable to us. As a law firm, we don't really put together these events or this workshop for the purpose of generating money. We're not a trade association. We're not an event planning venue. We are a law firm, and we put together this event in order to provide content and also provide an opportunity for industry professionals to network with each other. So we are very grateful to each one of our executive sponsors who help us to pay for the event. So as an example, CFT Pay, which is now part of Priority, it's a publicly traded company. They are sponsoring the opening reception. And Fourth is sponsoring the breakfast. So if you're having breakfast, it's covered by Fourth. CDRI, Consumer Debt Relief Initiative, it's a trade industry association, which I was very proud to start about 4 years ago. There are agreed to sponsor part of the lunch, and we're waiting for another company to agree to sponsor the other portion of the lunch. And Veritas Legal Plan has been a fantastic sponsor over the years. They're doing the closing reception. And again, extremely thankful and grateful to all of our sponsors, because they help to pay for these events, and you get a chance to meet all the wonderful individuals from these companies. So a very big thank you. Now, we have a lot to cover, and let's see how we can do within just the 1 hour time frame. We'll do our best. Here's what we want to cover. Overview and history of CCFPL, background and purpose. As you know, from those of you who have attended before, I always want to discuss the background and purpose. I don't believe any new law or regulation serves justice to be discussed without understanding the purpose and the legislative intent behind it, or any intent behind drafting behind of the specific regulation. Then we'll go into when these regulation will go into effect, who the regulation will affect, how the affected entities can register, what the requirements will be. So the when, who, how, and what, right? And then whatever additional requirements and penalties and violations. And finally, the implications of the new regulations for affected companies in preparing for compliance. So quite a lot to cover. Oh, and one other thing I do want to mention. Let me tell you. I do want to say that I'm very thankful to IAPDA for inviting me to speak and doing a presentation about the post-election effect on the debt settlement industry. This is going to be IPDA's inaugural event coming up in just a couple of weeks, I believe in 3 weeks, Yvonne, right? And our entire firm is going. Yvonne's going to be there, and Jessica's going to be there. So if you are, I urge you to attend. IPDA is a great association and industry where you could get certification. So I hope you attend and you get a chance to meet with us in South Florida. Sorry, I forgot to mention that. Okay, so CCFPL. Obviously, I'm not going to go into the several legislation that were introduced by a number of legislators, California legislators in 2019. Went to significant lobbying efforts by the trade associations from the debt settlement space, and finally, through numerous revisions, were signed into law on September 25th, 2020. And the purpose of the legislation under the Consumer Financial Protection Law was to strengthen consumer protections in California. Also, as part of it, the name of the agency, which used to be called DBO, Department of Business Oversight, which to us lawyers seemed a very bureaucratic name for an agency. It was finally changed to something a little bit more 21st century. Department of Financial Protection and Innovation, DFPI. Sounds a little bit more exciting. And so now we call it the DFPI instead of DBO. I just think that's a little bit more exciting. So now the DFPI becomes sort of the national model for consumer protection. And you probably have heard the DFPI to be typically called the mini CFPB, right? The DFPI is arguably one of the more active regulators in the country. We deal with DFPI all the time, and they have multiple divisions that just oversee various facets of segments of not just consumer finance, but different areas of products and services. And it's not uncommon for other state regulators to look up to what the DFPI is doing. So it'll be interesting to see if other state regulators will possibly mirror some of these rules if they decide to adopt them. This law in 2020 gave the DFPI the authority to have the ability to increase the scope of business activity that the entities regulate, including debt settlement companies, debt relief companies, credit repair, consumer credit reporting companies, debt collectors, private student loan companies, payment processors, and others. And obviously, it provided the DFPI the ability to, propose and promulgate more rules. Now, a little bit more background. Under its authority, given the DFPI proposed regulations in April 2023 to establish specific registration requirements for providers of 4 financial products and services, 1 being debt settlement, 2 student debt relief, 3 education financing, and 4 income-based advances. Now I'm going to focus just on the debt settlement portion, right? Because obviously most of those who are followers of our webinars and they focus on the debt settlement portion. The DFPI said, in part, that the reason they wanted to focus, for instance, on debt settlements is that providers necessarily serve economically vulnerable consumers because providers' clients are struggling to pay their debts. I'll read this. It's right down the slide. The proposed regulations, when they proposed it in 2023, the proposed regulations are intended to strengthen consumer protections in the financial services industry, particularly for vulnerable consumers, by requiring certain financial services providers to identify themselves and examining those providers for compliance with consumer and financial protection laws. The DFPI will help protect California consumers. Data collected by providers will inform the DFPI examination priorities, assist the DFPI in identifying consumer risks, and ensure that providers are able to perform their obligations to consumers. The data will help DFPI research, analyze, and report on markets for consumers' financial products and services. So 2 things I want to take away from here. Number 1 is, obviously, the DFPI jurisdiction is solely limited to the consumers in the state of California. And I want to be very clear, in a number of investigations I was involved with them, they wanted to extend their reach to other states. And, I could tell you that, they did limit it to the state of California, and that's what these regulations allow them to do. They allow them to collect data and information by regulating companies that transact business with the state of California. The second piece is really the data. They're looking at the data, right? And data is gold, right, to regulators, right? They want to take a look at the data from once the reporting requirements go into effect, and Yvonne will talk about it during the presentation. And that data will be analyzed in terms of are consumers better off, for instance, in comparing to other debt relief industries, bankruptcy, for instance, or should they be in credit counseling, or should other disclosures be made available? What are the risks? So ultimately, data is very, very important to regulators. Clearly, just from experience, state regulators don't typically move as fast as federal regulators, so it probably will take a few years for them to analyze the data and to have some kind of reports. But it is quite important to note that they focus on the data. Okay. So the third time is a charm, Yvonne, right? Was that the third time that they modified modifications? Yep. And it's interesting, between the first time they introduced and the last time, which is the third time, the rules didn't really change. It was really the procedural aspect of how the rules are proposed delayed the implementation of the rules. And even on October 11th, when the rules were announced on DFPI's site, I remember I called Yvonne and I said, hey, it looks like they're proposing the rules again, but then we get a Westlaw alert, and the Westlaw alert said that the rules are final. So the background is I had Yvonne called the California Office of Administrative Law, and they said no, it's final, it's actually final. And if you subscribe to our newsletter, you received for the initial alert that they've been proposed, and then and when Yvonne spoke to an attorney at the Office of Administrative Law, the attorney said no, they're going into effect on February 15th, 2025. We updated our alert, which was somehow met with some skepticism by other regulatory attorneys in this field. But of course, if we stand behind our words, and the DFPI, I don't want to say they corrected, but they announced just actually last week, in fact, that is going to affect on February 15th. So in any case, yes, they were finalized on October 11th, and they are going to affect February 15th. If you don't think it's serious, please go to the DFPA website. It's all right there. So that's the date when they will become going to affect. That means that you need to submit your application by February 15th. Okay, so you have plenty of time, and we'll talk about the application in a few minutes. Plenty of time to submit your application. It is, it's not a simple application, but it's not something that out of this world. The reality is, you really, without submitting the application, I don't think you're going to be able to do business. And I think the DFPI, what I consider to be what I consider the enforcement division to be one of the more aggressive enforcement divisions, they will take enforcement action. Maybe not at the beginning, they'll probably give some grace period, but eventually I think they will start taking enforcement actions if they're going to start seeing companies operate. Now, let's get to the fun stuff. Okay, I try to really go quickly for this, so if I'm going quickly, I apologize, because as I said, there's a lot of content to cover. Now, who's required to register, right? The $64,000 question, right? And we probably could spend a few hours talking about it. We're not going to do that, and so Yvonne and I are going to digest this. And if you're going to attend our in-person event, which is, we like to always have dialogues with the participants, I imagine there's going to be a discussion about this. So any person who engages in the business of providing subject products to California residents, unless exempt. Subject products under the regulations include debt settlement services. I think that's pretty clear. Okay. Debt settlement services means, and this is directly from the regulation, and I'm going to read this, okay? I'm going to read it with, and then Yvonne and I are going to discuss this, right? We're going to nerd out about this, right? Providing advice or offering to act as an intermediary, including but not limited to offering debt negotiation, debt reduction, or debt relief services between a consumer and one or more of the consumer's creditors in connection with consumer's non-mortgage debt, if the primary purpose of that advice or action is to obtain settlement for less than the full amount of debt, or reduction in the interest rate of payment associated with the consumer's debt, or advising, encouraging, assisting, or counseling a consumer to accumulate funds in account for future payment of a reduced amount of debt to one or more of consumer's creditors. Now, the definition of debt settlements is not convoluted. It's pretty clear. Would you say that, Yvonne?
Yeah.
Yeah, right. I mean, we've seen worse, right? I think one of the worst ones we've seen is Illinois. I think Illinois is horrible. We could probably do a whole class on Illinois, but we're not going to talk about Illinois, okay? But what's interesting is there are a couple of things that's very different in this specific definition than other definitions of debt settlement services. The words of non-mortgage debt, usually the words are used as unsecured debt. I don't know why the regulation says non-mortgage debt, because non-mortgage debt doesn't necessarily mean all non-secured debt. I'm just kind of, playing a little bit of a lawyer here, because that's, mortgage has its own definition. And then the word advice, right? Usually, you have like providing advice or offering to act as an intermediary, and they put a comma there. the word intermediary is a very common word. If I took universe of the statutes of what debt settlement is, the word intermediary appears probably in about 75 to 80%, and that's really the crux of what a debt settlement company is. It's an intermediary between a creditor and a consumer. But the word advice is, I don't know if I remember seeing it anywhere. Usually it's an offering or soliciting. The word advice is a very strange word because what does it mean to providing an advice,
Mhm.
right? What does it mean to providing an advice? Is a sales call providing an advice, right? So that becomes very fact specific. And I will explain to you why we're saying that. I mean, clearly debt settlement companies have to be registered. But the big question is, well, what about those who introduce business to debt settlement companies, right? The marketing companies or front end companies. What about you, Yvonne? What do you think about this?
Do we want to go ahead and move to the next slide and discuss it further, or do
Sure. Yeah. Let's move on. So I know we kind of nerded out a little bit on the definition, but
you?
you want to talk about the front ends before the attorneys. You want to
Yes,
talk about this
yes.
particular? Okay. So we'll kind of jump right in the middle of this
Yeah,
slide.
we're gonna jump right in the middle here and just, I think it's important to note that if you actually look at the initial statement of purpose for these regulations, as it relates to marketing, the only mention of marketing in the approved regulations is a requirement for applicants to provide a description of how their services are marketed. And if you actually go to the statement of purpose document, regarding that requirement for registration, DFPI has stated that, in its experience, many financial service providers use third party marketing to acquire new customers. And these third party marketing partners may use unfair and deceptive advertising. And by requiring registrants to identify their marketing and customer acquisition partners, will help the DFPI deter such conduct through risk-based examinations and enforcement actions. So I think this is a really important distinction to make between those whom DFPI is expecting to register, which clearly it's not necessarily expecting marketing companies to register. However, they are expecting debt settlement companies that use these marketing companies to identify these marketing companies so that they do have this data when it comes to enforcement and examinations, is in particular when it comes to unfair and deceptive advertising, which is what we see them harp on, time and time again, not just in California, but in other state regulatory enforcement actions.
Okay, so that's kind of interesting. So the distinction is made right in the propose when they're proposing this and discussing the right, the kind of the what I would call, I don't know if the proper terminology is legislative history. Is that even the proper terminology in the regulatory? Because that's usually for state or federal,
Right.
or the background of a regulatory proposal. Um, and I'll tell you, this, I'm going to go back to the previous slide. I think the word advice is going to be a very controversial word, right? Because other than the word advice, I think it's pretty clear that they're looking to regulate intermediaries, right? Um, one could say offering to negotiate, offering to debt negotiation, debt reduction. But again, the focus here is here again, act as an intermediary, right? But basically, the focus is they're using the word intermediary. That's the purpose of it. And even if you're going to go here, advising and encouraging, assisting, or counseling a consumer, well, again, the question is, um, okay, advising, again, use the word advice or advising, right? Encouraging, okay, encouraging could be, but do front ends or do marketing companies, do they encourage you to accumulate? I see these scripts all the time. I don't typically see them say that you should accumulate funds. Usually that's done typically, during the onboarding process. So the bottom line is it's going to be very fact specific. It really will be very fact specific. So I want to be very clear, right? Because, um, you know, um, at our event last year, there was an interesting discussion about this issue. And so I kind of making it known that whether marketing company front ends, my view, and this is not legal advice, is these laws are not created to regulate marketing company front ends. But if But if there's someone that's just taking the position it should, then again the same question is, why wasn't it made clear? And then what is really the word advice? Now I'll tell you what my opinion about the word advice. And here the reason is, that's the next slide is, there is no exemption for attorneys. And that's, for as a regulatory attorney, that's quite puzzling, because pretty much except for one state, I could think of every state having, so first of all, CCFPL doesn't have an attorney exemption, and these regulations do not have an attorney exemption, right? You know, when attorneys have a legal model when they try to do business in states, and also don't forget, many attorneys who are just solo practitioners or sometimes the bankruptcy lawyers will offer to do debt settlement. Not to say that this is their primary purpose of business, but sometimes they will offer debt settlement because it might just be easier and quicker, and the client, the consumer, may not want to file Chapter 7 or Chapter 13, right? That's where the word advice comes into place, right? Because attorneys provide advice, right? And they will encourage you to accumulate funds, right? Because if you think about, what do attorneys do? They encourage you to say, look, you've got to start saving money. You've got to accumulate these funds. And so they also advise you, right, in this entire debt negotiation reduction. So I think that's more applicable to attorneys, the word advice, advising or encouraging. That's my personal view. Again, obviously, look, as a as a lawyer, I could tell you, could put 5 lawyers in the room. 5 lawyers will have 5 different opinions. But Yvonne and I love to discuss this, and I thought that we're going to spend a little bit of time discussing it at this webinar. But the surprising thing here is there is no attorney exemption, right? What do you think, Yvonne?
Yeah, it's extremely surprising. And it will be interesting to see, how this takes effect in the months to come, and whether we see, a large number of attorneys registering, and how DFPI will handle that.
Also, if you're a California lawyer and listening to this webinar, and you're in the business of debt settlement, I would love to hear from you personally. I'll tell you why. Well, first of all, obviously, just like you, we are regulated by our respective bars, and wherever you get licensed, we're regulated by the state bars, right? So we have our state by state rules of professional ethics. I never, as a lawyer, had to register anywhere, and for performing services as a lawyer. So that's one. The second thing is, I don't know if any lawyers are familiar with this, or they're going to know about this, because if you're, when California is a $40 million market, right? Population of 40 million. And you've got your mom and pop shops, and, they do a couple of debt settlements, right? And they may not even be aware of this law, this regulation. They may not pay attention to this. They're immediately breaking. Will the DFPI be sanctioning them? I think it's a little strange, in my opinion. I also don't understand why California did not create this carve out. If Yvonne and I missed it, we'd love to hear from you. But based on our research, we did not see any exemption. So we'd love to hear from you. But we're kind of interested to see. And just to give you an example, because I'm admitted in England and Wales. In England and Wales, as a solicitor, and I'm not a practicing solicitor in England and Wales, but if I wanted to perform certain services on behalf of my clients in certain financial services areas, I would actually have to be registered with the UK FCA, right? UK Financial Conduct Authority. That's right. There's actually attorneys that are required to be regulated individuals. But that's kind of across the board, and they know that. And it, that's kind of known from the moment that you get accepted into the on the role of solicitors. I don't know if anybody in California knows about this, so I'm just kind of pointing out to you, and I'd love to hear if you agree or disagree. It's a very interesting issue. Payment processors are not affected by these regulations. There's no mention. Payment processors are just governed by a different area of law, so we just mentioned it here. So we spent a lot of time discussing it here, and I think, Yvonne, we should move on.
Yeah.
Okay. Okay, this is you.
All right. All right. So we are going to get down to the nitty gritty. So what is the fee for registration? applicants have to submit a $350 application fee with their application. And in order to maintain your registration each year, you have to submit a $100 renewal fee. As far as application fees and renewal fees go, this is pretty low. I've seen fees, go up into the thousands. So nothing really exorbitant here. Regarding how you can register, I know many of you are interested in, how can I get this process started? So all registration applications, amendments, notices, filings, supporting documents, etc., are going to be filed electronically with and transmitted through the Nationwide Multi-State Licensing System and Registry, or more popularly known as NMLS. There are some additional supplemental documents that you have to submit directly to DFPI, which I will also go through. But if you aren't familiar with NMLS, this may be the time for you to kind of just take a look on their website. They offer, a lot of great supplemental guides about how to get an account started, processing applications. So just definitely give it a look, and be prepared to use that system to maintain your registration and apply for registration. And as far as NMLS goes, they are also very helpful with answering questions. I'm also very familiar with NMLS and work with it, very frequently for all sorts of registrations and applications. So, if you are a client of ours, or if you wish to be a client of ours and need help with NMLS, I'm more than happy to provide that for you. So what is the information that you'll need to provide on NMLS? So I'm going to go through some of these rather quickly. Like Felix mentioned earlier, if you would like a copy of the slides, please let us know. I usually don't try to go through this as quickly as I am, but in interest of time and because there are a lot of requirements, I'm going to kind of be breezing through these. So just general identifying information for the applicant: name, address, phone number, email, etc. Any trade names that the applicant has need to be included. You need to include your registered agent information for California. You need to include a list of all of the web addresses you will be using to offer or provide consumer financial products or services to those California residents. You need to provide the name, address, email number of a contact employee. And DFPI actually also requires you to, once you're registered, separately register an employee and information for contact. So, you need to make sure that your employees are up keeping tabs on NMLS and DFPI for any correspondence from those entities. You will need to provide a management chart that identifies directors, officers, managers, etc. You will need to provide this one. I'm going to spend a little more time on. You will need to provide information on each entity under common ownership, which means affiliates, and each entity under the applicant's control, subsidiaries that provide consumer financial products or services to California residents. And you need to provide information on whether you are controlled by certain financial institutions, and the relationship of that institution to the applicant. So, they want to know, whom you are associated with, what companies are under your common ownership, and what companies are under common control with the applicant.
And I want to just to really jump in really here, specific to California. Probably the only other state I would mention it would be New York with NYSDFS. These two agencies, CIDFPI and NYSDFS, very specific in analyzing common ownership. Yvonne and I, as I mentioned, we do work in the payment space, and we've submitted a number of applications to CIDFPI for money transmission. And I could tell you just from experience, granted, it's a completely separate group, different people. They pay really close attention and on the ownership structure. Now, I don't know who yet will be working in this. To be completely candid with you, I think this is going to be a brand new group of people, and they might migrate a few folks from other departments. Probably not payments because that's like a beast of its own. But anyway, be very careful with this, right? If you fail to disclose ownership of affiliates or subsidiaries, it might jeopardize your application. I could tell you that I would not be cute about it and not disclose it. CADFPI, from experience, I could tell you, and we deal with pretty much every state. In fact, on this very webinar, we have state regulators listening right now, and they're probably smiling right now. I could tell you, California arguably has some of the best analysts, and they not to downplay other states, but I could tell you they do a really great job analyzing these applications, and particularly when it comes to ownership. Yep.
Yep. And
Excellent.
then kind of following that, you're also required to disclose and provide complete information on criminal history, regulatory actions, civil actions, and financial history, kind of, going off of, that same um, idea that Felix was mentioning, DFPI will look into these. So don't be cute about like leaving any information out of these disclosures. These regulators have access to enforcement actions across all states. So do not be surprised if, you forget to mention something in your disclosures and it comes back to bite you when you get your deficiency notices back. Continuing as to on the requirements for registration, you also need to provide information on direct owners, executive officers, indirect owners. They will have to submit their own individual form on NMLS. Like I said, you can read more information about how to do that on NMLS. They have a lot of guides. However, you don't need to provide a credit report or fingerprints for these individuals, which is pretty nice as far as applications goes, and will help, for you to gather the requirements a little bit quicker. Could you go back to the last slide, please?
Well, that's right. Sure.
No,
Sorry.
that's one more forward. We went back, or no, that's it. Yep. And then finally, you need to provide on NMLS a detailed description of your business activities relating to the provision of debt settlement. So that includes a description of all your products and services, a detailed schedule of all the charges that you will be associated with the product and services, a description of how you're going to market those services to California residents who may be consumers of the subject products, including identifying any websites, social media accounts, third-party brokers or lead generators that the applicant uses to acquire potential California consumers for its products or services. So this was the requirement that I mentioned earlier. DFPI is going to be looking at these third-party companies that provide these marketing services and taking note and accumulating that data. You also need to provide information as to whether you will be offering these through a mobile application. Can you go to the next slide, please? And then in addition to all of that information and documentation that I just mentioned that needs to be provided via NMLS, you also have to submit directly to DFPI images documenting the standard enrollment and or application process that you'll be using to offer debt settlement services, including anything through a mobile application or website, documentation of the standard enrollment process for over the phone. You need to do you need to submit standard enrollment materials, applications that you provide to residents in connection with the offer or sale of the product, copies of contracts, disclosures that you will provide, a list of any addresses where you will be working from to offer or provide these products to California residents. You need to provide your gross income for the prior calendar year from debt settlement services, provided to California residents. And finally, you also need to provide sample periodic account or activity statements used for debt settlement services.
Which, by the way, is as we're going through this, because again, like going back to what I mentioned, I'd love to hear from the California attorneys, since there's no attorney exemption. I'd love to see how the attorneys are going to be compiling all this information and how some of this could be. Now, I'm not saying all of this, but some of this might have some attorney-client privilege issues. Not obviously the images of promotional material, but I'm just kind of just thinking a little bit. Anyway, we're gonna probably go through this really quickly, right, Yvonne? Do you
Yep.
mind if I
Yeah,
quickly?
yeah,
Yeah, go
absolutely.
ahead.
So this is just really for your reference. And all of the information that I just stated before, you can see the specific questions requesting all of this. I checked right before the call, and these applications will open on NMLS on November 1st. So that is Friday. So you can begin compiling the application items and accumulating this information on NMLS on November 1st.
Yeah, and you could see obviously these are we put them in here in the presentation. It's a lot, but it is starting in 2 days, and um, typically. From experience, especially, I think the big last one was in Virginia. Everybody rushed to submit the application, and then they couldn't process on time. And there was a question, can we operate in the state? And look, the earlier you submit it, the better, right? So you want to start gathering the information as soon as possible. And um, I wouldn't wait until the 15th, February 15th to submit it. So, and if you haven't used NMLS, um, definitely take your time to register and learn it. There are actually courses available online. It's not the easiest platform to use, and yeah. So let us know if we could be of help. All right. So how long does it
Um,
take?
yeah.
That's probably the big question.
All right. So how long does the registration process take? So like Felix said, you know, we're going to expect that there's going to be a massive influx of applications toward the beginning. And, you know, perhaps they state within the regulations that within 30 days of submitting all of your requirements and paying all fees, you should receive either notification that your application was approved or deficiencies from DFPI. I have never submitted an application and not received a request for deficiencies. So,
I don't think anybody's ever done. I think they have to find something. It's the deficiency, but so
so
expect that.
you can expect at the very least, you know, this process to take, you know, anywhere from 60 to 90 days. Just given at least one deficiency notice. It is important to note that after the third review of an application, and if it's still incomplete and there are still deficiencies, the commissioner will deem the application abandoned, and you will have to submit a new application fee if you wish to submit a new application. It's important to note also, though, that an abandonment of an application doesn't preclude you from submitting another application. It just means that you're going to have to pay more fees. So are there any annual registration or reporting requirements? Yes, you must pay an annual fee, currently $100, to be assessed on or before November 30th, on or before December 31st of each year. And then in addition, every registrant who is registered as of December 31st must also file with DFPI no later than March 15th, beginning on March 15th of this year, an annual report containing the following information. The registrant's gross income for the prior calendar year from subject products provided to California residents, the number of California residents who had an existing contract for debt settlement services in effect at any time during that prior calendar year. For residents identified, the total number of debts they've contracted for with the registrant. For the residents and debts identified, the total dollar amount of the debt of all residents who contracted for services with the registrant. So, you know, like a lot of data, they're asking for all of this data about, you know, how much debt is being loaded with these providers, and how many residents are using their services. In addition, they would like the total dollar amount of the charges paid by all residents, the total number of debts for all residents who contracted for services over the contract term that have accepted settlement with a creditor and made at least one payment pursuant to that settlement. For the debts identified, which a resident has accepted a settlement at any time, the average amount owed upon execution of the contract, with the settled debts, et cetera, et cetera. And then finally, for those debts identified that, have gone through settlement and where the consumer has made a payment pursuant to that settlement, the average amount of time between the execution of the contract and the first payment under each settlement.
Look, in summary, they want a lot of data, right?
Yes.
And what a lot of data basically means is that eventually the regulators are going to stop doing audits, right? They're going to look
Mhm.
at the data that you're submitting. They're going to look at it over the course of, probably several years, and they're going to compare your books and records. They're going to come in. So whatever CRM you're using, whatever um, repository that your company is using to store, make sure that it's working. And this is the time of good CRMs. This is the time of good storage solutions, document retentions, and you know this to me is basically smells nothing short of these companies will eventually get audited. Some of them, not all of them, but eventually.
All right. So, what are the penalties for violating these regulations? So, a violation of these regulations constitutes a violation of the CCFPL. And we have listed for you, the penalties associated for violations of the CCFPL on the slide. You're going to see a lot of big dollar amounts on there. And I don't really want you to focus so much on that. You will have to pay a fine. The DFPI, like Felix said, is operates like a mini CFPB. So for you can expect that you will be fined if there is a violation.
Yes, Governor Newsom likes to collect his fines. So if you live in California, you know that.
Mm.
So, um,
All right. So how should you repair? While the registration is not available on NMLS yet, it's available on Friday, November 1st. You can prepare by just beginning to gather the required information and documents that have been discussed. Just start gathering that. Like Felix said, the earlier you apply, the better. Less risk that you run into any issues with concerns about operating and still being in the application process.
and bottom line, if you're in compliance department or legal department of any decimal company that operates on multi-state basis and you submitted applications, whether or not you use NMLS or not, you probably have gathered some of this information before and you can recycle it. So yeah, you probably it it it's not, in my professional judgment, I don't think it is the most difficult application. It's just a very bureaucratic application.
Mhm. Yes.
So now, here's a little kicker, right? And this is we just added this yesterday, um, and that's the funny part, right? And we thought we were done with the presentation, and 2 days ago, um, the DFPI sent out a notice, and then when I also want you to know um, the way we work here at my firm is that we like to digest a lot of these things, right, Yvonne? And we typically there's no like partner counsel or partner like we discuss like what do you think? Like we discuss this, and I don't mean to bore you with it, but you stuck long enough. I want you to understand that the opinions that you hear from us, these are genuine opinions. And for those of you who know us, you're not going to hear fluff, right? So we got this email. You've probably seen it, and the DFPI on October 28th, 2 days ago, they asked for stakeholders, seeking stakeholders' input on what other industries the FBI should establish registration reporting requirements for under the CFPL, and DFPI noted several potential rulemaking topics for comment, few of which listed below. I mean, it's right there. And basically they're looking for new categories of registrants, oversights, and reporting requirements. So these four, I'll read them verbatim because they're pretty simple. I don't like to read things verbatim, but one is, for what additional industries should DFPI establish registration requirements on the Financial Code section that's 90009? Anyway, what other industries, right? Let's kind of make it simple. What consumer protection risks do those industries present to consumers that would make it appropriate to prioritize the registration, right? So what other protection risks in these industries, right, are important and should take priority? And then the DFPI invites stakeholders to submit examples of acts or practices in these industries the stakeholders find concerning, right? What are the concerns? Just making it simple. And for each industry suggested for registration, what trade associations, if any, represent that industry? Okay. And by the way, there are other there in this commentary for stakeholders. There are other points. What information the DFA is seeking, but obviously these are the four core. So Yvonne and I were brainstorming this. Yvonne, why don't you tell me why you think they sent this out and what's interesting to you?
So Felix and I, yeah. So like we said, we like to digest this, and we were discussing this, the morning after it came out, and I think it's interesting that while the CCFPL was passed in 2020 and came into effect January 2021, we only saw these proposed regulations were just approved, the debt settlement registration regulations in 2023. So it took, it took 2.5 years for DFPI to develop these regulations for registration. And, once these now have been developed, they're seeking to expand it already within, just a few weeks of the approval. So it's interesting to know. I don't know what caused DFPI to stall so long from the passing of CCFPL to now, to now expand its oversight and require registration over not just these four sets of groups, but also additional consumer financial service companies. I don't know if it was just they didn't have the personnel in place yet required, is one of my theories. Felix, I don't know if you want to share any of your theories as
Sure.
well.
The timing of it was very interesting, right? And that's one thing we agree on, right?
Mhm.
My first suspicion is, okay, I don't want, maybe it's the word suspicion is not the right word. Uh, Question is, why now, right? So the ink is barely dry. By the way, we're about to send out, if you subscribe to our newsletters, we're going to send out an article later today about this. Um, it's published on JD Super under our firm name if you follow it. But anyway, the ink is barely dry, right? It just announced it last week, or I mean, publicly, right? Technically, 2 weeks ago. The ink is barely dry, and now you're already looking to what other industries, what else, right? So my question again is, well, did you have to wait for these four categories to be finalized to ask? You know, I don't think so. I think that they could have asked us before. I think they could have. They proposed rules now for quite a long time. For well over a year. Went through third round, even though it wasn't really substantive to that many changes. But they could have asked what other industries. They could have asked this before. While this is getting finalized. But now that it's finalized, it's like, what's the rush, right? And I say they can't do it. I don't think there's anything that prohibits a regulator to ask, but just to like it's almost the world is burning and they need to come up with new to regulate new industries. So what's prompting this, right? The question is, did they hire new people? Is there new leadership? Did they move over people? Like it's just so unusual, right? So I look at it when you deal with state regulators and when they promulgate rules, when they propose rules, it doesn't typically move in a very fast manner. But but the ink is barely dried here. They're looking to new categories, right? So who else do they want to regulate? And why wasn't this previously discussed? It's nothing bad. By the way, I want to be very clear. These are very good proactive um, proposals or comments, right? These are very good. I'm not against it. I'm just questioning the timing of it. The timing of it is very questionable. And then the comments are due December 12th, which is, well, frankly, that's like 6 weeks. Um, we're kind of heading into holiday time. I'm not saying people will say pens down, but you know, why couldn't this be done earlier? Why couldn't this be done in the summer or fall? Like this is around Thanksgiving time. I don't know. And I also wish there was more time, perhaps. So, any case, the timing of it is a very question. I'm sure there's a simple explanation. Well, of course there is. There's always a simple explanation, but the timing of it is very interesting, right? Um, and if and it's going to be interesting to see what those comments are going to be and what those other industries are going to be. So just wanted to end with this presentation. As I'm looking at my clock, it is 1:57, so we actually did make it within the hour. So I think we did a pretty good job. I want to thank everybody that you stuck around. We actually did not have a single person drop, which was pretty impressive as I'm looking at the count. I want to be very grateful to all of you who participated. I hope to see you, first of all, again. You'll meet all of us at IAPDA in South Florida in a couple of weeks. I urge you to go. It's the first inaugural event, and I'd like to. Oh my God, we actually still have our old address. We need to update our address. We moved from that address. I apologize. We're no
Oh,
longer at
goodness.
once. That's fine. That's fine. If you show up there, we're not going to be there. Two is I hope to see you. Two, I hope to see you obviously at our annual event. And by the way, last year the event was sold out, and it was sold out about 2 weeks in advance. So people will be buying tickets for $75. You're getting two receptions, breakfast, lunch, and really great content. I think, Yvonne, I was standing at our last at 4:45 because we finished at 5, at 5 to 7, then we have that closing reception, happy hour. We had a packed house, which makes me very proud that our team did a great show and our presenters. We have amazing content. Please register. It will sell out. It will sell out really quickly this year, and it's not a hard sell push. It's just going to sell out because it's just probably because of the success we had, and it's a fifth year. So thank you again for listening. Thank you, Yvonne, um, and we'll see you at our next webinar.
Thank you all.